So let's talk a little bit about the creditors meeting and what you should expect at a creditors meeting. And first of all, what is a creditors meeting? Well, bankruptcy law is federal law. It was established under the federal Constitution that Congress shall make uniform the bankruptcy laws throughout the United States. So actually for 100 years Congress didn't act, and in the 1890s they created the Bankruptcy Act. And under the Bankruptcy Act, one of the requirements of the debtor was to appear at an administrative proceeding called a creditors meeting. And the creditors can appear at that meeting, but you usually don't see them. It's maybe a creditor appears once a year at a creditors meeting. But at the creditors meeting, the trustee, whether it's a Chapter 7 trustee or Chapter 13 trustee, will ask you some simple questions. Did you review the petition with Mr. Conway or someone at his office? Did you sign the petition? Did you list all your assets? Did you list all your debts? And then he'll ask you, in a case of a Chapter 7, I see you have 4 bank accounts. These are your bank accounts, and you'll have to say yes or no. And then he'll say, is this the balance on the date of the filing? And you'll have to say yes or no. And then the trustee, he or she, will ask you, do you have a house? Do you own real estate? Do you expect an inheritance? Is this your last filed tax return? And then if there are any other questions that they have about your bankruptcy schedules, they'll then ask those questions. But that's the general questions that they ask. Of course, the big issue at the very beginning is they want an ID from you. Not a real ID yet, but I suppose that will be coming. They want an identification from you, either in the form of a state driver's license, a military ID card, or passport, and then they need your actual Social Security card or the actual W-2 form from your employer. Those are the basic requirements at the creditors meeting. And they'll put you under oath, and either myself or one of my associates will be there with you. Now, how should you dress to this creditors meeting? I don't really require that you dress. I mean, I will be there in a suit because that's what lawyers do. I don't think you should show up in a suit, but I would say dressy casual. And the one thing that does make me cringe occasionally is a client will show up in t-shirts and jeans or wearing shorts, and that's really not appropriate for the proceeding, and also suggests maybe to the trustee that you're not giving this your full attention, and that you should have it's a more solemn proceeding than that. So I think it's certainly appropriate to dress in a dressy casual manner. I would like you to bring your bankruptcy petition with you. Now, as you know, I scan your bankruptcy petition and give you the original back. Except if you're in Charlottesville, the law requires me to keep the original, and I'll give you a copy. But bring the original or copy with you to the creditors meeting. Also bring your tax returns with you. Now, my staff will have asked you for a bank statement, and they're not asking for the bank statements that you gave us originally a long time ago before you filed. What they want is a bank statement that shows the balance on the date of the filing. So if there's any question about it, literally, look at the notice of bankruptcy filing that I gave you, or that we gave you, at the time when we met to review your petition. See that date, and then make sure your bank statement includes that date. Sometimes, clients will say, well, I filed in August. So they'll hand us the August statement. Unfortunately, the August statement frequently does not include the month of August, or all bank statements frequently do not include the entire month. Instead, the bank statement ends sort of mid-month, or maybe the 20th or 21st. So you have to pay close attention to that, and that's what the bankruptcy trustee wants to know. What was the balance on the date of filing? Now, I don't know why the trustees are obsessed with this, but apparently it must yield money because that's what they will ask. Other things that happen at the creditors meeting. The trustee may ask you about your statement of intention. And if you have a secured debt with your bankruptcy petition, we filed a statement of intention. And that would say if you owned a house, generally that you intend to stay in the house and to continue to pay the mortgage. And if you owned a car, we will say that you intended to reaffirm or redeem the car, unless of course you wanted to surrender either of those assets, which does happen from time to time. That's your statement of intention. The trustee might ask, have you carried that out? And generally, no one has carried out their statement of intention by the time of filing or by the time of the creditors meeting. And in fact, you have 30 days after the creditors meeting to carry out your statement of intention.